in this system. If you're in this court, you've been charged with a felony, not a misdemeanor. You're not in county court. These are serious crimes that have maximum sentences of up to 5 years, if not more. So if again, I'm going to ask you if you want an attorney, and then I'm going to enter a not guilty plea on your behalf so that you can speak with your attorney and figure out how to proceed with your case. So I'm just letting you know that so you can kind of see how we're proceeding. So I'll just go through the regular docket. Those that have attorneys will be mixed in with those that do not. So beginning with Travis Anderson. Is Ms. Flowers here? She's not here. Hold on. Okay. I think your attorney got out front on this. She already entered a not guilty plea. Do you have her contact information? You do not? Do we have regional conflict? Just look in the phone. Just Google it, Regional Conflict Counsel. Do we have a copy of it? Just look it up and make a call and make an appointment with her to go over your case, okay? You have any questions? Okay, thank you. Christopher Chase.
The efforts for Christopher Chase, and we'd be entering a plea of not guilty for today and setting this for the next pretrial conference.
That would be 12/27, correct? Okay. Mr. Anderson, leave. Right here. Mr. Anderson, I forgot to tell you, your next hearing is December 27th. Okay, 9 a.m. Jessica Cossen. State, would you announce?
Yes, Your Honor. It is 22 CF 2370.
State.
Your Honor, I don't see anyone, so I would request a capias.
Court will issue a capias. Heather Creech. Yes. Creech? Heather Creech. The state announce, please.
Yes, Your Honor. 22 CF 2452, charged with possession of controlled substance, possession of drug paraphernalia. I do not see anyone present. State would request a capias.
So ordered. Zero bond capias. Cody Hinesley.
Your Honor, Casey Etheridge for Cody Hinesley are here, and I believe the 2022 CF 2449, there's a pending competency evaluation. And so, Your Honor, we'd be asking to set this with the other case on the December 28th docket.
Very good. The court will continue this until December 28th, 9 a.m.
Thank you.
Caitlin Hodges.
Good afternoon, Judge.
Good afternoon, Mr. Williams.
Hodges is present in court. Jay Williams for the defense. I'll enter a plea of not guilty. Demand trial by jury. Request 15 days to file any pre-arraignment motions.
Court will grant we'll take the plea of not guilty and we'll reschedule for a pretrial on 12/28.
Thank you, Judge.
I'm sorry?
1227.
12/27. Thank you, Madam Clerk. 12/27.
Thank you very much.
Thank you.
Somebody always has to be right, and it's always the clerk.
That's good. Robert Jones. Robert Jones.
22 CF 2502, charged with possession of controlled substance and paraphernalia. No one appears present. The state would request a capias.
Court will grant the request, zero bond capias. Victoria Kelly. Come up to the podium, ma'am. Would you state announce, please?
22 CF 2385, she is charged with possession of controlled substance and possession of paraphernalia.
Ms. Kelly, you do have a right to an attorney with this matter, as I mentioned. Do you wish to have an attorney appointed? Court will appoint the public defender. The court's going to issue accept a not guilty plea. We'll come back at our pre-trial, which will be 12/27 at 9 a.m. Okay? Be in contact with your attorney in the interim. Monisha Larkins, if I pronounce that name correctly.
22 CF 2395. Your Honor, Ms. Larkins does not have an attorney at this time. I have conveyed the state's offer, and she has indicated that she wishes to accept the state's offer and plead no contest to a lesser included offense of drug paraphernalia, receive a withhold of adjudication, credit time served, $5.15 in court costs, $50 cost of prosecution, and 180 days to pay. I do have the plea form that's signed. May I approach?
You may. So this is a misdemeanor that does not require a score sheet, correct?
Correct, Your Honor.
Ms. Larkins, would you please raise your right hand? I just need to ask you a few questions. Do you swear or affirm that the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, sir.
Okay. So, I know you're not an attorney, or I assume you're not, but there's a lot of legal stuff in this plea and sentencing agreement. Are you comfortable entering into this plea agreement without consulting with an attorney?
Say it again.
I just want to make sure you understand what you're doing here today. This obviously is I'll just say it's a good plea agreement.
Okay, yes, sir.
But it does affect you legally. You know, there's going to be something on your record. I just want to make sure you've had whatever questions you have based on your record and based upon everything, what are the options, so that you have the right to make an informed choice. You don't want to just have somebody twisting your arm, or you think, well, they told me I had to do. I want to make sure that you're comfortable doing this. So, do you feel comfortable doing that, or do you want to try?
I feel comfortable.
Okay. And you understand that by entering this plea, this will be a final resolution. You're waiving the right to go to a trial and to contest all this. This will be a final resolution of your case. Do you understand that?
Okay.
Yes?
Okay.
Okay. And you are entering this freely and voluntarily? Nobody's twisting your arm to get you to enter in
No,
this?
sir.
Okay. Very good. Based upon that testimony, the court will accept your plea of a lesser included charge of drug paraphernalia. There'll be a withhold of adjudication, credit for time served, $5.15 in court costs, $50 cost of prosecution. You'll have 180 days to pay, or it'll go to collections. Okay?
Yes, sir.
Okay, question?
No, sir.
Okay, thank you very much. Randy Perez.
Your Honor, he was here this morning, and I informed him that Ms. Flowers had entered a not guilty plea,
Okay,
but had given a new court date of 12/27.
very good. Thank you. Robert Sapp.
22 CF 2388. Judge, Mr. Sapp currently does not have an attorney. However, I did convey the state's offer for arraignment to him. He's indicated he wishes to accept the state's offer. He will be entering a plea of no contest as charged to both counts, and in exchange receive a withhold of adjudication, credit time served, $100 cost of prosecution, $515 in court costs. He will have 180 days to pay. And may I approach with the signed plea form and the score sheet?
You may. Mr. Sapp, you just heard the state attorney state the terms of your plea agreement. Is that your understanding of what the plea agreement is?
Yes, sir.
And are you in agreement with that?
Yes, sir.
I see that she's written out the the terms as well as some other language in the plea and sentencing agreement. Did you get a chance to review this?
Yes, sir.
Plea and sentencing agreement? Do you have any questions about it? I know you're not a lawyer, but I want to make sure that if you have any legal questions, that you have the right to get an answer, or even, have an attorney appointed if you feel like you need one. You feel like you understand this
Yes, sir.
situation enough? You understand you're waiving the right to go to a trial. This will be a final adjudication of your case. You understand all that?
Sir.
Okay. Very good. Based upon that testimony, court will accept the plea agreement, and the defendant will enter a no contest as charged. There'll be a withhold of adjudication, credit for time served for both counts, $100 cost of prosecution, $515 in court costs. You'll have 180 days to pay, and if you can't pay it within that period of time, then it'll go to collections, okay? Question? Okay, thank you. Timothy Schlegel, if I pronounced that correctly.
22 CF 2334.
Your Honor, Tim Gibbs on behalf of Mr. Schlegel. He's going to
Is it
enter.
Schlegel or Schlegel?
Schlegel.
Schlegel.
Legal, my bad.
Okay.
Oh, yeah, they just want you over here.
Schlegel,
Schlegel,
like
Schlegel.
legal, but it ain't.
Okay.
That's just a copy for you. That's what you were charged with. Your Honor, Tim Gibbs on behalf of Mr. Schlegel in 22 CF, 2334. We're executing a written plea at this time. He's going to enter a plea of no contest. Terms of that plea are going to be withhold, time served, and the associated court costs. If I can approach with the written plea and a score sheet.
You may. Thank you. Thank you. I'm going to announce the plea.
Yes, Your Honor, it's withhold, time served, and the associated court costs due within 180 days.
Okay, very good. States in agreement?
Yes, Your Honor.
Mr. Schlegel?
Yes, sir.
Would you please raise your right hand? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, Your Honor.
You heard your attorney state the terms of the plea agreement. Is that your understanding of what the plea agreement is?
Yes, sir, correct.
And I see that you've signed the plea and sentencing agreement, contains that as well. If you had a chance to just make sure and have any questions, you have legal questions of your attorney, had them answered?
Yes, sir.
You satisfy, you understand what's going on here?
Yes, sir.
Understand you're waiving the right to go to a trial?
Yes, sir.
Final adjudication of this matter?
Yes, sir.
Okay. Nobody threatened to coerce you to get you to enter into this plea?
No, sir, just,
Okay, very good. Based upon that, the court will accept your plea and will sentence you to credit for time served. The court costs and fees due in 180 days as per the agreement. If not, it'll go to collections.
Thank you, Your Honor.
thank you, Your Honor.
Thank you. Charles Singletary. The state announced.
22 CF 2418.
Just come up to the podium here, sir.
Mr. Singletary's been charged by information with tampering with evidence, resisting without violence, paraphernalia, and driving while license suspended.
Okay, as I said, Mr. Singletary, you do have a right. You do have a right to have an attorney appointed with these charges. Do you wish to have an attorney appointed, or are you going to hire private counsel? Want a public defender appointed? Court will appoint the public defender, and as I mentioned, I'm going to go ahead and enter a not guilty plea on your behalf, so you get a chance to meet with your attorney. We'll come back for our regular pretrial on December 27th, 9 a.m. Just be in touch with your attorney in the interim.
Please make sure to fill this out and submit it to the clerk, and then that's our office number if you can.
Patrick Smith.
22 CF 2500. Mr. Smith is currently unrepresented. I have given him the state's arraignment offer. He's indicated that he wishes to accept and plead no contest as charged to both counts, receive an adjudication of guilt as to both counts, credit time served, court costs $515, $100 cost of prosecution, have 180 days to pay. I do have a signed plea form and a score sheet if I may approach.
May. So, Mr. Smith, I just need to ask you a few questions. Would you please raise your right hand? Let me swear you in. Do you swear or affirm the information you're about to provide this court is the truth and nothing but the truth, so help you God?
Yes, sir.
So, Mr. Smith, you heard the state attorney outlined the terms of the plea agreement.
Yes, sir.
And I see that you've signed the plea and sentencing written agreement that contains those same terms.
Yes, sir.
So, do you understand what's contained in this agreement and understand what the plea agreement is that
Yes, I
you're
do.
agreeing? Are
Yes, I
you in
do.
agreement with that?
Yes, sir.
Have you been able to have all your questions answered
Yes,
to the
sir.
degree? And she's not your lawyer, obviously can't give you legal advice, but do you feel like you understand what this all means?
I do.
You understand that you're waiving the right to go to a trial. It's
sir.
important, valuable rights.
Yes, sir.
This will be a final adjudication. You can't come back and say, I changed my mind, I want to do something different.
I'm good.
Probably won't happen, okay?
Yes, sir.
And nobody threatened or coerced you to get you to enter into this?
No, sir.
Free and voluntary.
Free and voluntary.
Very good. Based upon that testimony, the court will accept your plea. You'll be plea as charged to both counts. Be an adjudication of guilt on both counts. You get credit for time served, and all the fees and court costs of $515 and $100 cost of prosecution. Get 180 days to pay it, and then it goes to collections.
Yes, sir.
Okay? Any questions?
No, sir.
Thank you. We need to get fingerprints. Here you go, man. Jacob Worf.
22 CF 2483.
He's in custody, Your Honor.
Yes.
He's the last one, except for Turner. He missed one, but he's the last one, except for. Oh, okay.
Your Honor, this is Mr. Jacob Wharf, present in 22 CF 2483. Tim Gibbs on his behalf. If I can have just one moment. We're just having to execute a written plea, Your Honor. There's costs associated that'll be due within 180 days.
Time, sir.
Yeah. 11-2. Do whatever they will with you. If I may approach, Your Honor.
You may.
No objection to this motion.
Thank you.
Your Honor, in this case, Mr. Worf is entering a plea of no contest. The terms of the sentence is going to be time served. The associated court costs that are listed there, that would be due within 180 days. He would be adjudicated guilty.
State.
That's the agreement, Judge.
Mr. Worf, would you please raise your right hand? Let me ask you a few questions. Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, sir.
So you heard your attorney state the terms of the plea agreement. And I
Yes, sir,
see
Your Honor.
that those same plea, the agreement is listed in the plea and sentencing agreement that looks like your signature is on that. You've signed that. Have you gone over this with your attorney to make sure that you understand what this means legally?
Yes, sir.
You understand that, you're waiving some important legal rights. Just want to make sure you're doing it of your own accord. Nobody's forcing you to do this?
Yes, sir.
Is that true? Nobody coercing you to do
Nobody.
this?
No,
It's on
sir.
your own free will?
Yes, sir.
Okay. You understand that by entering this, you're waiving the right to go to a trial. This will be a final adjudication of your case. Do you have any further questions of your attorney? Okay. Based upon that testimony, the court will accept this plea. The court will, do we have an adjudication? Is there a
It's
withhold?
Very down at the bottom, Your Honor, I
Correct.
believe. There should be an adjudication.
There's an adjudication. So they've been adjudicated guilty of the one charge. You'll get credit for time served. So you're not going to serve any additional and no probation. Got a number of fees and costs that are due in 180 days that are outlined in your agreement. And if you can't pay it within 180 days, it'll go to collections. You're not going to get picked up, put back in jail if you don't do it.
Yes,
Okay? You understand that?
Yes, sir.
Okay. Thank you. Good luck.
Thank you, Your Honor. Good luck. Just take a fingerprint.
I think that's all we've got on the pleas, correct? Hold on a second. There's a couple people waving their hands out in the, sir, would you stand up and identify yourself? Ralph Thompson?
Your Honor, I represent Mr. Thompson.
Okay.
Tim Gibbs for Ralph Thompson, 22 CF 2436. He'd like to enter a plea of not guilty this afternoon. If we could just leave this set on the next pretrial.
How's it not on my docket? Was it added?
He may have been an add-on.
I don't
have
mind, but I'm just
Yeah.
kind of,
And I'm looking at the transport list. I see several others, inmates that are also add-ons for this afternoon.
okay. We'll enter not guilty, that's fine. Do we have that, Madam Clerk? Did you get the number?
Yeah.
Okay, very good. So we're coming back on our regular pretrial. It'll be December 27th at 9 a.m., 12/27. Make sure to meet with your attorney in the interim.
Yes, sir.
Mr. Williams?
Judge, Ms. Harrell this morning that failed to appear in the court issue of habeas is here. If the court would like to go ahead and, I'm just going to do with it what I did with the other case and ask the court to set it for 12/1. But do you want to lay eyes on her and perhaps speak with her? And I will say
Would
this,
we-
Judge,
would
I did
you-
not
would you-
contact her over lunch.
Hold on a second. We got to make sure and get the correct case number so the clerk's got it. I don't have it in front of me.
I don't either, Judge.
Do you have
It
that,
falls
Madam
in my
Clerk?
court.
Amy Harrell,
Yes.
it's 20 CF.
Okay.
We're recalling the case.
The state okay with recalling the capias? Ma'am, did you not get the 9 o'clock this morning?
I did, yes, sir. I overslept. My alarm went off, and I did not
You have
hear
to get
it.
some backup, get somebody to remind you,
Yes,
because
sir.
not, they're going to be coming picking you up, you're going to be coming through that door.
I
You know
know,
what comes
I
through
know.
that door? You
No,
don't
sir.
want that.
No, sir, not at all.
Okay. So the court will withdraw the capias. The court will,
Judge, I'm going to ask.
we'll just
to pass it
continue it
12/1.
to 12/1 at 9 a.m.
Okay.
Okay, and in the interim, meet with your attorney so you
Thank
can
you.
figure
Yes,
out where
sir.
you're going with everything, okay?
Yes, sir, thank you.
Thank you.
Thank you, Judge.
Thank you, Mr. Williams. We got three other folks.
Judge, we have number, well, we have Daniel Turner, who's not represented.
Daniels Turner,
Daniel Turner, he's number 17 on the 130 one.
not on my docket.
Coming up. Number 17, on 130.
Oh, I've already gotten a not guilty plea on that.
Oh, okay.
Who wrote the not guilty plea, though, if he doesn't have an attorney?
I don't have him as a not guilty.
Okay, that's what I have on mine, so it's a mistake. So,
I did convey the state's offer. He does have some questions, so I feel like the public defender should be appointed at this time.
so, Mr. Turner, this is case number 22 CF 2501. First order of business, you do have a right to an attorney. You wish to have an attorney appointed?
Yes, sir.
So the court will appoint the public defender, and as I mentioned, I'm going to go ahead and enter a not guilty plea on your behalf. We'll come back on, when do we want to come back? 12/27,
That'd be great, Judge.
9 a.m., and just meet with your attorney in the interim, and maybe you can work something out, okay?
Yes, sir.
Question?
No, sir.
Okay, thank you. Who else? A couple other folks back here. Do you all have their names? Come on forward, man, and then we'll get you, man. Come on. Come on, stand up at the podium. Would you identify yourself?
Jones?
Sheila Jones. She's n- Did Mr. Williams slip out on us?
I think he did, Judge.
I guess he did.
Russell, will you run him down if you can? I think we've got your attorney, there he is. Mr. Williams, I think you got another client up here.
Yes, sir. Or yes, sir.
Why is he not on this docket? Why did you take him out?
Okay, come on.
Is this for arraignments, Judge?
I don't know. It's not on my docket. We're just trying to, apparently they've got notice, it's not anybody, I mean, not y'all's fault, it's apparently the system. We'll blame it on the computer.
Let's see if I can bring her up on.
Do we have a case number, Madam Clerk? And was that for arraignment here today? Yes. Okay.
All right, in that case, Judge, and in the old days, I used to just announce on all public defender cases, but what I'll do is I'll enter a plea of not guilty on her
Correct.
behalf, request trial by jury, and request 15 days for any pre-arraignment motions.
Very good. So we'll
Thank you
come
very
back on 12/27 at 9 a.m. And hopefully you'll be able to interact with your attorney and kind of figure out where things are going, okay?
And that's 12/27, Judge?
Yes, sir.
Thank you, sir. Oh, okay, sure.
We'll hang one tight. We got,
I knew I was
let's
going
get these
to pick up some today.
folks
so
that aren't
I'm
here.
Leaving.
Why don't you come forward, ma'am?
I'll have a seat and just wait on
Well,
you
let's,
guys.
do we know that, who's this lady? Would you identify yourself, ma'am? Come on. Come forward. You're good, ma'am.
Ms. Jones?
Sorry, we're a little discombobulated this afternoon.
Yep, you're good to go. Yep.
Jacqueline Lige, sir.
Lizer?
Lige, Lige.
Lige? Jacqueline Lige?
I assume so. I don't know. It's not. I would
Madam Clerk,
assume.
is this for arraignment as well?
I was real proud. I finished all my arraignments by 2 o'clock, just on time.
Did she,
Plea day?
is
Why
it
don't we
been
just go ahead
filed?
and take it today? We're a little early.
Okay.
Is it a VOP or a new law? We're gonna enter a not guilty. Do you have the case number, counsel?
I do not, Judge.
Would you give him the case number again?
Her daughter, Desiree, and continuing to try to get Desiree here.
Okay, so then we're not gonna enter not guilty, but we'll come back. We'll come back on pretrial or,
That's fine, Judge. I'm not, I'll look and see when the information was filed, if it wasn't enough time to do anything.
hasn't been
with it.
filed yet, they said. Yeah, let's bring her back on November 10th. Is that in the morning?
It's at 1:30.
Yeah, 1:30. Okay, that'd be great.
I can explain everything that's going on.
Yes, sir.
If you want to have a seat.
Thank you. Thank you, Judge.
We'll get you a notice, ma'am. Hold on just a second, ma'am.
We're going to get you a piece of paper to remind you of everything.
That's for
Miss
him.
Elisa? Elisa?
Miss Lige.
Elisha? Well, that's all right. We have a notice for you. Let's remind you to come. Okay. Amanda Harville. Do you have a case number, Madam Clerk? Sorry. Is this an arraignment as well?
Yes, she has her information.
All right, Judge, enter a plea of not guilty, replace 15 days for pre-arraignment motions, demand jury trial.
Court will accept the not guilty plea, and we'll continue this for pretrial on 12/27, 9 a.m. Just be in touch with your attorney in the meantime, okay?
Sure, and set an appointment, okay? I'm
Okay.
difficult to deal with if you
You got
don't.
4?
Harris? Eldron Harris?
Mr. Harris, what's your first name?
Eldron.
Eldron. with an
Madam
E?
Clerk, can you help
Yeah,
us out here?
Eldron.
There's next 4 inmates we don't have.
Yeah, the case number is 22.
Has been,
Judge, I'm going to enter a plea on Mr. Harris's behalf, plea of not guilty, request trial by jury, and 15 days for any pre-arraignment motions.
court will accept your plea of not guilty, and we'll come back on December 28th, 9 a.m.
Thank you.
Be in
And I'm gonna
touch
be
with
out
him
to
in the
jail.
interim,
See you in a
okay?
couple of days.
Jackson? Henry Jackson, sir?
Hey, Mr. Jackson. Mr. Jackson, I'm Jay Williams. I'm representing you. Madam Clerk, do you have a case number on him? You want to put him on the 10th as well, see if we have an information by
Yes.
then?
November
not-
10th at 1:30.
I'm going to be out to the jail and explain to you what's going on, but basically, you don't have a formal set of charges, but they haven't passed the date by which they have to have that, okay? So the 10th will bring you back in.
I ain't got no choice.
You don't know what formal charges means because I haven't explained it to you. So I'm going to come out to the jail, and I'm going to explain it all to you, okay? But the short version is they have not filed the formal charges against you. You're still in jail on the officer's opinion of what you should be charged with, which was what you were booked under. But the officer is not a prosecutor, he's not a lawyer, he can't represent the people of the state of Florida, only the prosecutor can. So they have to file the information, file
do I
the
get
formal
charged?
charging document.
We had a single
Get charged for being a passenger in the car.
You shouldn't be. And in a perfect world, they'll enter what's called a no prosecution, and you won't be. But you were arrested for it, and so we've got to do something with it, okay?
When my court did it,
Next one's going to be November 10th. Hopefully, they'll have either done a no pros or filed formal charges by then. Who's next?
All right. Mr. Kenneth Singletary? Singletary? This is Tim Gibbs.
22
Oh, okay.
2456.
Your Honor, Tim Gibbs on behalf of Kenneth Singletary, 22 CF 2456. If I have just one moment. Sorry. There we go. So you scored 23.15 months on this case. Okay, but if we can't do it today.
I'm trying to get it over with, huh?
Your Honor, on Mr. Singletary's case, we're very close to resolution. Just a couple details that we need to work out. Hold on. So for today's purposes, of course, we'll enter a not guilty plea, but I'd like to set him on the arraignment date for November 10th. Believe we'll have it resolved that day.
Okay, very good.
So she's just.
Enter not guilty, and we'll come back on November 10th.
I'm gonna miss a charge. I don't have a criminal charge.
I know. Like I said, but she's got to go confirm the restitution first.
It is.
Next Thursday. Next Thursday.
Last one's going to be James Willoughby, sir. Willoughby.
Tim Gibbs on behalf of James Willoughby, Your Honor, this is case number, if I can find it, case number 22 CF 2415. If I can have just one moment. It will. It's just you're officially charged now. But they'll dismiss the petty theft. That's what you want to do. Go ahead, sir. Well, he's gonna ask and make sure that that's what you want to do. Hearing will probably be next week, though. Yeah, we wouldn't have one hearing until.
Sweet.
I can file it to try to put it on next week.
What do we got, Mr. Gibbs?
I think he's making a decision, Your Honor.
See if you can get my monitor to stand out.
Your Honor, I think today we'll enter a plea of not guilty. We'll leave him on pretrial, and then I believe in the meantime, we may be filing a bond motion.
Absolutely. Yeah, you can bring him back anytime. Enter not guilty plea, come back on 12/28.
Thank you, Judge.
Thank you.
I do have one other person on docket, Your Honor. He's out of custody. Ronald Ward, I don't know if he showed up on your docket or on an add-on docket.
Not on mine.
He is present, and we are ready to resolve his case.
What? Where's? Ask and see what.
I do have that case number, Your Honor. It's 22 CF 2470, and we do have a resolution, if I can approach with the score sheet. No objection to the score sheet. As the terms of the plea indicate, he's going to enter no contest plea this afternoon. He'd be received with withhold of adjudication, be placed on probation for 12 months. While he's on probation, he'd have to perform 25 hours.
12 months probation for each of the 3 charges?
I'm sorry, concurrent. I can write that.
I know they're concurrent, but are they, each one being the same amount?
Each, yeah, total of 12 months probation.
But they're concurrent. Yes, you need to put for each charge and that they're running concurrent. That's technically what's happening.
Thank you, Your Honor.
All right. If not, the record will be confusing. Okay.
Yes, Your Honor. As you know, as noted, all counts concurrent for 12 months of probation. While on the probation, he would, of course, have to pay the court costs that are associated and noted on the written plea, perform 25 hours of community service, have no contact with the alleged victim. The name is listed there on the written plea agreement, and not trespass at the scene of the location. It doesn't have a specific address. It's on,
Got to have an address.
it's a parcel number that I can put on there.
Got to put something on there, because if not, you can't hold somebody accountable for. I want to make sure it's clear so you don't, inadvertently do something to violate. Oh, so, okay, so go ahead, let's go ahead and ask you a few questions while he's getting that in. Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, sir.
And is the state in agreement with this? So you heard your attorney state the terms of the plea agreement,
Yes,
the
sir.
core of which is 12 months probation for each of the 3 charges, right?
Yes, sir.
Okay. You understand that by entering this plea agreement, you're waiving the right to go to a trial. This will be a final adjudication of your case. So have you had a chance to kind of ask any of the legal questions of your attorney, make sure you understand what you're doing here today? And are you satisfied with your attorney's representation?
Yes, sir.
And are you entering this
Yes, sir.
agreement voluntarily?
Yes, sir.
Okay.
It's that parcel number off Cotton Creek Road.
Very good.
Parcel number of the plot. Your Honor,
Okay.
noted there.
Appreciate it.
Off of Cotton Creek Road in Baker.
Okay, very good. Okay, so, Mr. Ward, based upon this plea agreement here today, the court will accept the plea agreement, have 12 months probation for each of the 3 charges. They'll all be concurrent. All the fees and costs you'll have to pay during the term of the probation. There'll be 24 hours of community service, no contact with the victim. His name is contained in here, and no trespass at the parcel number on Cotton Creek Road in Baker. Okay, good?
Thank you, Your
very
Honor.
much.
So just before you leave, okay. I believe that concludes my business, Your Honor. Oh, I do have I'm sorry. I was mistaken, Your Honor. I do have one other person he wasn't transported. I just wanted to enter a not guilty plea on the record for him, if I may.
Is he in jail?
He's in jail, Your Honor.
Is he on the list today? He just wasn't transported?
I don't see that he's actually on the transport list at all. But I believe,
Do you have a name?
our clerk has it. Drick Reese, 22 CF 2435. I would just want to enter a not guilty plea on his behalf.
Or to accept the not guilty plea. We'll come back on pretrial,
Retrial, Your Honor, 1228.
1228.
Thank you, Your Honor.
And Your Honor, on this award, we're requesting supervision be waived if Mr. Gibbs did not ask so.
So ordered. Okay.
I have a couple of FTAs that are no attorneys.
It's not on my docket, so I'm not taking any action on it. You all need to get me a docket.
Ham?
Not on my docket, I'm not addressing it. Okay.
Your Honor, one of the ones you addressed was a Heather Creech.
Correct.
That's, my phone just went off, and that was her on the phone. She is a co-defendant of James Ham also. I don't know if that's why they were together. And just passing that information along as I know it.
Very good. Okay. Hate to start off apologizing, but we're running a half an hour late already. We've got 5 cases this afternoon, one of which is going to be a lengthy sentencing. And maybe a couple. Ms. Bassa, how long do you anticipate?
Your Honor, I spoke with Mr. Russell. We think maybe a half hour, 45 minutes max. I'd say half hour would be a good bet, because I only have one witness. She's a child we'll need to clear the courtroom for.
Right.
Judge number 4 on the afternoon docket, Mattingly, that's going to be a plea.
That's a plea?
Yes, sir.
Okay. And we've got a Nelson hearing on James Terrell. So, what I would suggest, because the other hearing is, I'm anticipating the Porter sentencing to be minimum of hour and a half, 2 hours.
State has 5 to 6 witnesses, Judge, and a couple exhibits. I've talked to Mr. LaPella. I don't know how many character witnesses are general plan on that. There may be a video that's admitted. I'm not talked about that. It may be an hour and a half.
If you've got 5 witnesses, there's no way it's going to be an hour and a half. No, I'm serious. That's not even a close call.
I might be ambitious with that.
How about, Mr. LaPella, how many witnesses do you have?
We're not anticipating a long hearing, but
Okay. Okay, so I think we can get the other things done by, in an hour. So I'm just letting everybody know that the Porter hearing, you all don't have to sit you can wait and come back. We will not begin that hearing until 3:30, but I think we'll probably start pretty close to 3:30, and we will finish today. If it goes past 5, we'll go until it needs to go, particularly with what's been said as far as anticipated witnesses. So, again, apologize for running a little late, but we'll try and do it. So we'll push forward right now with the other 4 hearings. We'll do the Terrell, and then Mr. LaPella, what's with Ivan King? What are we doing on that case?
motion to establish the expert witness fee. We've provided documentation of his established fee that's been spent for Dr. Rose.
Okay, so that shouldn't take long. I mean,
The state's disputing it, so I don't know.
what do we, okay. Okay, so we'll be doing that, and then we've got the plea agreement, and then we'll do Larry Jack the last before we do Porter. We also have to do, obviously, Mr. Keach. So, so we'll just go right down from the top down. We'll start with yours, Mr. Keach. So we'll start with James Terrell But anybody's here for Porter, you don't have to stay around. We will start right around 3:30. We won't start before 3:30. I apologize for making people wait.
Tables only if you're going to be here a long time. And Judge, just for the record on Mr. Charles, do you have a copy of his motion or letter to the court from July 18th pulled up on?
I reviewed it, but I don't have it in front of me. Sure. When was it filed?
It looks like July 7th is when it's dated, but I believe it was received by the court on July maybe 18th. Originally sent to the public defender's office.
I'll find it.
Can you hear?
Can't hear her now.
You need the device. Here now?
Can you hear me, Mr.
Yes,
Mr. Terrell?
Yes, I can.
Okay. So, Mr. Terrell, this is case number 2021 CF 929 and 21 CF 1577. We're here today, Mr. Terrell, on what's generally referred to as a Nelson hearing. And a Nelson hearing is based upon a case that's cited as Nelson. And it's basically the case when you are trying to discharge your attorney. So I need to ask you some questions. I'm going to put you under oath. Tell me what you want to do and see if it's appropriate to discharge your attorney if you still want us to. Okay, so hold on a second. Let me swear you in. You swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God.
Yes, sir. I hadn't done nothing but told the truth through this whole thing. So.
Okay. So my first question to you that leads up to everything is, are you wanting the court to discharge your attorney?
Sir, for one thing, I don't know if I'm totally mentally capable of doing this right now. I had a fall and hit my head in the concrete.
So you want to put off this hearing?
Well, for one thing, I didn't know we were having this hearing today. I thought they were getting me out to go see
Okay. Okay.
a scan, what do you call it?
What are we looking like on the 10th?
Well, what,
Let me just say, I just need to ask you the first question that you need to answer, and then we'll figure out where we're going. Are you wanting to discharge your attorney?
well, actually, I sent my attorney a letter. I don't guess he got it yet.
Mr. Terrell, I need to get a yes or no answer. Are you asking the court to discharge your attorney? If you're not, I'm going to end this and you can go and meet with your attorney and move forward. If you want to discharge him, I've got to ask you some questions because you have a right to discharge your attorney.
Yes,
But
sir.
listen to me, but I don't have an obligation then to give you another attorney in certain circumstances.
Okay, sir.
Okay.
Can we leave it? Can we put this off then? And maybe then if he, what I did is I told him if he can do something different, Your Honor, that I would,
Okay. Why don't we do this? What do we got on the 10th? I know we're back.
We already have 6 set for the
Okay. So we'll come back on the afternoon of December 1st. Between now and then, try and meet with Mr. Keach and figure out whether or not he wants to proceed with this Nelson hearing. How about that?
that would work, yes, sir.
Okay?
Yes, sir.
Okay. December 1st, 2 p.m.
Okay. Mr. Keach, I sent you a letter.
Okay.
I'll be on the lookout for it.
Thank you very much.
Judge, that concludes my business. May I be excused?
Thank you.
Thank you, Your Honor.
Thank you. Ivan King. Mr. LaPella, would you announce the case and tell us why we're here?
Yes, Your Honor, thank you. State v. Ivan Maxwell Ryan King, 2020 CF 2403. Sean LaPella for the defendant. Before the court on a motion to establish expert fee. Was filed on 20 September. I understand the state's objecting.
Yes, Your Honor. Customarily, expert witness fees to take a deposition are generally paid by the party who has the expert. And when Mr. LaPella's expert insisted that we pay the fees, that is when he filed this motion. There's really no case law on the issue for criminal payment in criminal cases. There is in civil cases. The only thing that I could really find had to do with if this case were to go to trial and they were to win, then the state would be required at that time then to pay fees that were expended in that situation. I've never had a situation where the state, or when I was on the defense side, that in a criminal matter that we were told that we had to pay the expert fees for the other side. And I believe one of the reasons is there's an issue of judicial fairness that comes into play. If you require the state to pay the fees, then when the state...
Before you go on, because you're saying you don't know of anything, any basis for it, let's see if Mr. LaPella can provide the basis for which he's seeking that, and then maybe it'll give you a chance to respond. Mr. LaPella, is this just kind of discretion of the court? Is this clear-cut in your view of
No.
what's...
In all of my years of practice, and I'm sure anyone else who's an attorney in this courtroom could establish, the way it works is that when we
Well, that's always a good way to start things off, counsel.
The way it works is we hire an expert. We pay that expert a retainer fee. They are our expert, okay? Any of the preparation they do in the case, whether it be looking over the materials of the case and advising us on things, preparation of their testimony, that's all paid by the defense or the retaining party. If there's a deposition, the preparation that goes into that deposition is paid for by the retaining party. But the deposition itself and the time that's spent when they're in deposition can be set, the fees can be established ahead of time, and that's the proper way to do it. And the state would pay for those fees. I've paid, as a defense attorney, I've paid for fees when I deposed the state's expert witnesses. I can vouch for that. There's even an expert in the courtroom today that I deposed recently.
So you're saying the basis for paying is based in your
No.
motion, or is?
Well, the motion speaks for itself.
Does it clearly lay out where I can read it and say, oh, yeah, you got to pay for it?
Yes, yes.
Where's it say it?
The rule, deposition of expert witnesses, it is established that the fee for an expert or skilled witness whose deposition shall be taken shall be allowed a witness fee, reasonable account that the court may determine. So why would we even have that rule, Judge, if the retaining party was going to pay all the fees? That doesn't make any sense whatsoever. So that's determined, it's the party deposing pays the reasonable fee. Okay? And I've even attached an order to the motion showing precedent that was, we had this issue come up in a prior case back in 2016. Actually, the trial was in 2017 in this circuit by Judge Brown when he awarded Dr. Rose, the state attorney's office should pay Dr. Rose at 2 hours, a rate of $750 an hour.
So that's precedent when a fellow circuit judge does that?
Yes.
Is that how you're?
So my
Yeah,
expert
no,
witness.
actually, the answer to that is no. Okay, I'll take it under advisement. Let
And
me
Your
just.
Honor, he is citing civil rules of procedure, and again, we could find no case to
So
support.
I just want, is there anything else that you've got based, other than what you put in your motion?
If this is where we're going, Judge, I'm happy to provide supplemental case law.
If you want to provide it, that's fine.
I would like leave to be able to do that because what the state is asking and what the state's asserting is absolutely not the way things are done.
And I'm not disagreeing. I'm just saying, this is the first time I've dealt with it. I just want to make sure I do it right. So that's why I'm taking it under advisement, and I'll make sure that I have a basis for what I'm doing. If it's as clear as what you're saying, then I'm sure I'll come to that same conclusion.
I mean, the motion speaks for itself. I'd be happy to provide its case law to the
If you
court.
want to provide anything further, you're welcome to.
How much time does the court want to give me and the state as well? I assume the state's going to provide something here.
How much time you need? On a week? I'm not going to.
That's fine, Judge.
week?
I can.
Is that good? I mean, I'm not going to.
I could provide it by Monday, I could have it.
Okay. Close the business Monday.
And can I ask one more question? Does the state dispute the amount of the fee?
Yes, the state would also dispute the amount of the fee.
Because I thought that's what the state was disputing and not
There
whether
is
or not there's a
issue-
basis for the
there
fee at
is-
all.
There is information out there, there are cases, there's discussion even in the rules about the amount that is normally paid in these situations. The JAC controls the amount that is generally awarded. In the situation where they want in excess of that, then you have to have a hearing, which is another reason why we're here.
And is the state conceding that the JAC pays the cost of these depositions for these experts?
No.
On behalf of the state? Because I think they
I'm
are.
referring to a situation where in, say, the public defender were to retain an expert, the JAC controls the amount of money that is paid to that expert.
Okay. Very good. If you got anything that you want to add, by close of business Monday, and same with you, and then we'll get it done. Okay. Thank you. James Mattingly.
Charles Russell, Public Defender's Office. Judge, this is Mr. Mattingly. Case number is 19 CF 1468, if I might have a moment. Judge, on Mr. Mattingly's case, we've reached an agreement with the state. This is a violation of probation, and in exchange for an admission of the VOP, the recommended sentence is an adjudication of guilt, revoke and terminate the probation, 150 days in the county jail with credit only since his last arrest, pay $100 cost of prosecution, $150 public defender fee, and he would have 180 days after his release to pay, or the amount would go to judgment. May I approach?
You may.
That's the agreement.
Thank you. Thank you. And defense okay with the score sheet?
Yes, Your Honor.
Mr. Mr. Mattingly, would you please raise your right hand, sir? Do you swear
Yes, Your
or
Honor.
affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, Your Honor.
So you heard your attorney state the terms of the plea agreement, and
Yes, Your Honor.
it appears to be the same terms that are contained in your written plea agreement, which you've signed. Have you gone over this, made sure you had all your questions answered regarding this plea agreement with your attorney?
Yeah, yes,
There's
Your
a
Honor.
lot of other legal impacts that have. In other words, by entering this plea, you're waiving the right to go to a trial, and it limits your right to appeal the case. So there's a number of legal ramifications of this. Just want to make sure you've had an opportunity to ask anything you want of your attorney to make sure you're clear about going forward.
Later on in my life, would I be able to expunge this case if possible?
That's a whole separate issue.
Okay.
I can't give you a simple yes or no answer on that.
Yes, Your Honor.
And I don't know that I would even if I could. It's a separate issue. Talk to your attorney about it. Does that impact your ability, does that impact you wanting to proceed today with this?
No, Your Honor.
Okay, I understand. It's a good question. I'd want to know that too, but I just don't have the answer for you.
Roger that.
It's not a simple, straightforward answer, honestly. I think that's the best answer. So, you've had all your questions answered, and you're entering this freely and voluntarily?
Yes, Your Honor.
Very good. Based upon that, the court will accept your plea. There'll be an adjudication of guilt, revoke and terminate probation, 150 days in the county jail. You'll get credit for time served only since the last arrest. Do we have a date for that to make clear?
I think it's in June sometime, Judge, the
June.
jail will know what we mean.
18th.
Okay, very good. As long as it's clear enough for them. Then the fees and costs, we'll have 180 days to pay, or it'll go to judgment.
Okay.
Any questions?
No, Your Honor. This is it.
Thank you very much. For this next hearing, there is going to be some child testimony that is going to require that certain